Hi, my name's Anthony Alder and I'm from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about a very new topic, and the topic is about an update of computer patents in Australia. Particularly what the issue is relating to these words manner of manufacture and what makes a patentable invention in Australia. One of the big problems is that at the moment the federal court has had sort of this topsy-turvy approach to looking at whether an invention is a patentable invention, particularly in the computer space. The federal courts rejected a whole lot of different software patents. These cases are included in the Encompass decision and the RPL decision. Recently, one of the decisions actually went on appeal to the High Court in Australia. Now, the High Court is the highest court in Australia, and it means that any decisions of the High Court are binding on all the lower courts. And those decisions are also binding on the Commissioner of Patents, which is the Patents Office. Now, the problem that the High Court was facing was whether a particular invention was patentable. And the invention they looked at was an invention made by a company called Aristocrat. And now Aristocrat makes electronic poker machines, and they file a lot of patents. In fact, in Australia, they are one of the most prolific patent owners. And they took one of their patents to the High Court to test that question of whether it meets the manner of manufacture criteria. Problem was that, and all the patent attorneys in Australia were all waiting for this case to come out, and we've got this schizophrenic decision of the High Court. And by that, I mean there were 6 judges on the High Court, and 3 of them went one way and 3 of them went the other way. And the deciding judge was actually sick on the day. So we're left in a decision where no one really knows which way to go. The case was decided against Aristocrat, partly because to prove it, you need a majority decision, and they clearly did not have a majority of the High Court deciding on it. However, whatever the High Court says in their decision is binding on the lower courts. So even though there was a description of the decision by the dissenting judges, that is still kind of binding on the lower courts and binding on the Commissioner of Patents, as well as the ones that were against the Aristocrat decision, which was what eventually happened. Their decision's binding too. So you've got these 2 sorts of decisions which are binding on the lower courts, which is quite a complex situation in this particular regard. Now, the problem is that 3 judges found in favour of Aristocrat, and what they found was that the electronic gaming system involving an artificial state of affairs and producing a useful result was capable of being a manner of manufacture. This is quite different to what the 3 dissenting judges found. A game couldn't be patentable if it was just run on a computer in a conventional circumstance, meaning that a computer that was just a regular computer running a computer game could not be patentable. The question beckons, well, did they really understand the invention that was being put forward to them? I don't think they really did, because in the Aristocrat decision, the actual claims of the patent weren't just claiming a computer. They were claiming a computer gaming interface, and that gaming interface displayed the symbols and logos in a unique pattern, a useful result in terms of an economic result. And to my mind, it was clearly patentable. Now we've got this sort of schizophrenic decision of the High Court. This is going to lead to a lot of uncertainty in the patent space, particularly with computer software. So my advice is, with computer software at the moment, we have to think about, does your invention meet a manner of manufacture criteria under the current legislation? And the way we do that is to have a look at whether your piece of software actually has an invention from what an IT professional would regard as being an invention, not just a general person in the public, but an IT professional. So if it's really just a matter of a piece of computer software that you've written that's a bunch of plugins that you've just plugged in off-the-shelf components and APIs, then it's probably not going to be patentable. It would be patentable if you've done it in a unique way. So say you've written a program that saves processor time or shifts processor load, or saves battery life, or is more security, or has a real world tangible outcome, then it is clearly patentable. But if you don't have that clear real world component to it, then you're going to struggle in Australia at the moment with the patents. And I think really this is a real cause concern for Parliament at the moment. And really the politicians should actually have a look to see whether the manner of manufacture test is still relevant in today's modern society. Whether it's lost its complete relevancy is a big question, and whether we should be moving to a separate new test and redefining the test of patentability. There was no intention when the test of manner of manufacture was invented that it complied with computers. In fact, the test of manner of manufacture goes back to the 14th or 15th century. So, in summary, what we really have to think about is what are the consequences for people with computer patents? Whether their invention is going to be patentable or not, and how do we test that? And I think if you were to test whether a patent is going to be patentable in terms of computer software, what we really need to consider is whether an IT professional would regard it as being inventive. I hope that helps you understand the current state of affairs with computer patents and the aristocrat decision of the High Court. If you need any help with any other further computer patent problems or understanding the aristocrat decision, please feel free to contact either myself or my team at Alder IP, and we are more than happy to help you. And thanks for listening.